Sir, I rise to move that the bill further to amend the Central Goods and Services Act, Tax Act 2017 as passed by the Lok Sabha be taken into consideration.
Thank you. Would you like to speak, Honorable Minister?
Yes, sir. With your permission, I just want to highlight what this amendment is all about. Sir, you are aware that the GST itself subsumed more than 17 taxes and 13 cesses of the states. Center and state, both of them got blended together into a single tax. Now, there are certain provisions and sections of the Act which give the power to levy the tax and also to review how these taxes are levied. In particular, Section 109 of the CGST provides for constitution of the GST Appellate Tribunal. Now, the Appellate Tribunal, when being set up, will also look at the qualifications, appointments, and terms and conditions for service of the President, and also the judicial and technical members are specified in Section 110 of the Act. 109 gives you the power, 110 gives you the details of what the qualifications experience will have to be now. Under the GST law, sir, adjudicating orders are passed by the GST officers from the center and state depending on the jurisdiction allocated to each one of them. Now, appeals are made against these orders which are passed by these adjudicating officers, and that appeal lies with the first appellate authority, who is an officer again within the tax administration and therefore of the respective center and the state. The second appeal against the orders of the first appellate authority under the center as well as under the state tax administration lies with the GST Appellate Tribunal. GST Appellate Tribunal. So, this is the first forum at which the GST litigation process converges within the state, that is, the appellate orders passed by the center and the state GST officers become a part of the same appellate forum, that is the GST Appellate Tribunal. Now, earlier in 2019, the GST benches, Appellate Tribunal benches, were notified, but the same was challenged in the High Courts. In its order dated 20th September 2019, in the writ petition which was in the case of the Revenue Bar Association versus Union of India in the Honorable High Court of Madras, the High Court held as follows, and I quote, sir, "The number of expert members, therefore, cannot exceed the number of judicial members on the bench," unquote. So, the Honorable High Court of Madras struck down Section 109 and Section 110 of the Central GST Act of 2017, by which we appointed the tribunal and by which the appointment, the qualification and the term, everything else was decided. Now that that got struck off, simultaneously the tribunal's reform of 2017 of 2020-21, which was brought in, also standardized the appointment, the terms, the qualification of all the tribunal benches, and the appointments which are being made to them have all now become standardized for all tribunals. That was happening parallelly. So, given all these developments, in the 47th meeting of GST Council, which was held in Chandigarh on 28 and 29 June, the GST Council discussed the changes that are to be brought in, and brought in such a way that the GST Appellate Tribunal in the GST law, which is there already in it, but it has to get constituted, we have to bring them in conformity with the judgment of the High Court, which was the Madras High Court. So, in the GST Council meeting, it was decided that we'll constitute it. So, the constitution also happened, constituting of these people, the tribunals were also happened, and Then it was realized. I'll just tell you what was constituted also, sir. The report of the group of ministers which went into seeing all this was submitted to the council, and the council then took a call that we amend the 109 and 110 of the sections. Then the amendment of the Finance Act, through the Finance Act in 2023, the GST Appellate Tribunal shall contain one principal bench and various state benches which are notified now. So the principal bench shall be located in Delhi and shall have a president, a judicial member, a technical member which is center, and a technical member which is state. The state benches shall also have two judicial members, a technical member of the center and a technical member of the state. All this was notified even by September 2023. Thereafter, sir, this is the immediate background of this amendment that we are placing before this Honorable House now. Thereafter, it was brought to the notice of the ministry by the Honorable Chief Justice of India in his administrative side through the registrar that the following aspect of the service and its terms are not in consonance with the provisions of the Tribunal Reforms Act of 2021. The Tribunal Reforms Act of 2021 brought a certain kind of rationalized approach to all the tribunals which exist in the country. And therefore, in alignment with this, the Chief Justice wanted the CGST Act also to be in line with it, and therefore the tribunal also to be formed in the fashion. So the 2 points on which the Chief Justice came in to advise us, and the advice has been well taken, is that the maximum age limit for the post of the President and the members is 67 and 65 years in the CGST Act before 2 days, if the House approves amendment. So the maximum age limit for the post of the President and members is 67 and 65 years in the currently prevailing CGST Act, whereas under the Tribunals Reform Act of 2021, it is 70 years and 67 years respectively. That is one point which was flagged by the Honorable Chief Justice of India. The second point that he pointed out, sir, is that the CGST did not have the provision relating to the eligibility of an advocate with a standing of 10 years at the bar for appointment as judicial member, whereas the same is available in the rules framed under the Tribunal Reforms Act. So if the Tribunal Reforms Act of 2021 had something and we didn't have it in the CGST, it wouldn't be right. So for appointing even advocates who with a standing of 10 years should also be brought in. So these are the two points which the Chief Justice of India have highlighted. We have now brought those as amendments to the current Act, and those are the amendments for which we are seeking the approval of the House.
Thank you.